Family court orders that restrict what a parent or party can say. For example, about the case, the judge, CPS, or the other parent are considered restrictions on speech and implicate the First Amendment. Courts, including in custody and child protection settings, generally cannot punish or reduce custody just because they dislike the content of a parent's speech, such as criticism of officials, unless they can meet a very high constitutional standard.
A Kentucky family court judge can issue orders that incidentally affect speech, but those orders are supposed to be narrowly tailored and justified by a specific legal interest. Examples where limits are more likely to be allowed: protecting a child from direct provable harm like speech that is likely to cause serious emotional or physical harm to the child, not just upsetting someone; preventing serious and imminent threats to the fairness and integrity of a proceeding. For example, a carefully limited gag order if there is a concrete risk to a jury trial or safety; prohibiting threats, harassment, or true incitement against judges, parties, or witnesses. Threats are not protected speech.
So now we are focused in on Fayette County, Kentucky Family Court Judge Tiffany Yar, the judge in Josh Anderson versus Cindy Adams.
She stated in post that she was ordering the girls' clothes that are anti-family court clothes for them to wear. It's right there. She posted these motions in this group that has over 11,000 people in it or so. She posted medical records. She posted ab-close communications with Mr. Anderson. All of it had significant personal information. Now, I know that this is a public record case, and I know that those records, if they're filed into this case, they are accessible. But you've got a whole pack of people that all believe that they have been wronged, and you're riling them up with the doctor's name, with your children's name, with everything. And that is so dangerous. It is absolutely so dangerous. And everybody can roll their eyes at that, but again, this is evidence to me that she's disconnected from the reality of the situation.
This clip showed Judge Yar framing Cindy Adams' online speech and advocacy as evidence that she is disconnected from reality and dangerous, largely because she ordered anti-family court clothing for her kids, shared filings and medical info in a large support group, and riled up others who believe they were wronged by the system.
She admits herself that everything Cindy posted is all public record. So what we are witnessing here is how the court publishes sensitive material all the time, but punishes parents who talk about it.
I will proudly and undeniably cut off Miss Adams' First Amendment rights. And
calling a large group of people who believe they were wronged a pack and suggesting that riling them up is itself dangerous sounds more like protecting institutional reputation than protecting children from concrete harm, but not as much as threatening to proudly and undeniably cut off someone's First Amendment rights.
The pack of people Judge Yar is referring to is the Family Court Fraud Warrior Project, a registered 501c3 charity legally authorized to engage in education, research, public advocacy, and whistleblower support related to government misconduct, and wouldn't even have to exist if it wasn't for corrupt judges, like Judge Yar.
Judicial conduct codes require judges to act with integrity, avoid abuse of authority, and respect constitutional rights. Threatening to strip rights because of someone's speech can violate those ethics and expose the judge and county to federal civil rights claims.